Ladies and gentlemen, get in here for a Tuesday night murder church coming through right now, and just in time for a new piece of Sarah Boone. A new motion coming down the pike here. She is looking for a new trial, and James Owens is presenting that in a motion to Judge Kranek. We're going to get in here and take a look at this and read through and give some opinions, hopefully in the chat, and I will be as well. Thanks for coming in. Let's go.
Sarah.
Just turn around, first of all. Put your hands behind your back. Do you have anything in your pockets that I should know about?
Why is this happening?
Because George is dead.
Not intentionally.
Let's rock.
Yo, everybody. Murder Church on the air. What's up? What's up, everybody coming in? Appreciate it. Yeah, we are here again. Murder Church, and it's Sarah Boone. I know last night I said that Phil Spector was going to be making a return, the Phil Spector Hollywood murder trial that we're continuing to do. We're about, honestly, halfway through that right now, which is insane to say, but a new little something came out today. We got a motion here filed for the defendant, Sarah Boone, for a new trial that she's trying to get here. I did a little bit of research today on some stuff, and I've got the actual motion here that we're going to read through and just kind of, so hopefully give some opinions in the chat, and I know that I will be giving mine as well, and see what you guys think about this whole thing. But everybody coming in here, I really appreciate it. Ritz coming in here. That's a new name. What's up, Ritz? Evening, y'all. Joy. More, it's all about Sarah Boone. Yes, Sarah Boone has returned, and we know how she likes to talk about herself. James Owens is presenting this here. Pokemon in the house. Love to see it. Love to see it. Karen Kelly. Justice for George all the way. Welcome in here, Karen. Appreciate it. Forrest Nelson hanging and banging. Love to see it. Thanks for coming in here. And Dizzy. And Jerry Wayne's in the house here tonight also. Yeah. Appreciate it, guys. Thanks for coming in. If you have not hit that like yet, please do so. And of course, like always, we got a will and play. But yeah, we're going to jump in here and see what we're looking at here tonight. Let me jump over here real quick. I've also got some notes up here I need to put up here just to make sure. But yeah, we're going to read through this thing. It's been a while since I've read through any kind of legal documents, so bear with me, please. Jenny Allison, what's up? What's up? Phil, what's up? Oh, also, yeah, Phil, I'm glad you popped in here. I've got this over here. This Friday night, at least I think it's going to be going down this Friday. Me and Phil was talking. Tayo Toys, right here, as you can see, we got two. Well, this one right here is for Lauren Conlon for her popcrime.tv. Hopefully you're following over there as well. But the publicly buzzed fucking rod right there, that hoopty. That thing is going to be given away Friday night for Feral Friday, everybody. So make sure you're subbed up. You don't want to miss that. We have a lot of cool giveaways and do some really cool stuff here. But yeah, let's jump in here, folks. Let's jump in here. Let's see what's going on. Thinks everything's looking fine and dandy. Sarah Boone, defendant's motion for a new trial. Comes now the defendant, Sarah Boone, by and through counsel and pursuant to Rule 3.600 Florida Rules of Criminal Procedure, files this motion for new trial, starting in support thereof the following. And I had actually made a tweet also that was kind of breaking down what this was. Florida Rule. Let me bring this out. Hold on. I'll fix this. Just want to show this off here. Bring that out. Florida Rule 3.600 of the criminal procedure states the grounds for granting a new trial in a criminal case. The jury reached a verdict by lot. The verdict is contrary to the evidence or the law. New evidence was discovered that could have changed the verdict or court's finding. The defendant's substantial rights were prejudiced. The defendant was not present at a required proceeding. The jury received evidence outside of the court. There's numerous of these. The jury separated without leave of court. A jury or the prosecuting attorney behaved. the court made an error on the matter of law. The court instructed the jury incorrectly or didn't give a proper instruction. The defendant didn't receive a fair or impartial trial. So let's read through here and see exactly what James Owens is going to bring forth from some of the things we just read that could maybe make this improper, and maybe we need to do something. What do you guys think? Does Sarah Boone deserve to get a new trial? Let me know in the chat there, first of all. Hopefully I have a drink in hand. Let's read through here. Again, bear with me, folks. No professional, no legal advice, just opinions. Comes now the defendant Sarah Boone through legal counsel. I just read that. 1. The defendant was found guilty as charged of second-degree murder on October 25th, 2024, as we all remember. The instant motion of timely filed pursuant to Rule 3.600 that we just read. The defendant asserts that she is entitled to a new trial under this rule on the following grounds. 1, and they've listed out 5 for us here tonight, folks. The court erred in ruling that the defendant was not entitled to court-appointed counsel. We know she went through so many different court-appointed. Just last night, we watched a motion hearing from a month ago where 3 of these attorneys were trying to get paid. The court erred in ruling Boone was not entitled, but they did on numerous occasions until she was beyond difficult. And again, she was even going to represent herself. Plus, this was the motion hearing before the actual trial. So this actually isn't even part of the trial. This was beforehand. 2, the court erred in denying undersigned counsel's multiple motions for continuance. 3, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. And we all remember that when they started showing the video of George in the suitcase and his mother couldn't contain herself and actually had to be escorted out. And I think she did make an audible noise, and they cut the sound on the feed that we were watching, at least the one that I was watching. But Owens in the court did at the very end make he made it known that how improper this was and this should never happen. I don't disagree totally there, but also, how can you control something like that? The family is in there and they see literally something like this. And who knows if she'd even seen that before? She probably had, but it's right there in front of her and emotions already running high. That's a difficult one. But legality wise, 4, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tonya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. Now, that was extremely interesting. That was at the very end of this thing. And you remember they had a deposition done in the middle of the trial by Owens. That Judge Kranick let that go down and let that happen. And it was proper that he probably did because of an instance exactly like this. He got to ask her questions. He got to get her opinions in real time with a deposition right there in the trial of Sarah Boone. 5, the state committed misconduct by essentially making a second closing argument instead of a rebuttal argument. So they're saying there at the very end, and this is a hard one. I've seen a few different professionals, opine on this today a little bit, and they were talking about basically how that's a hard one to kind of get past and by. And even in on the day that this happened, after the rebuttal, Owens didn't make any mention of this. We're going to get a little bit deeper to why he thinks this as well. Thanks, everyone, for being here. Really appreciate it. If you have not hit the like yet, please do so. We have a good time here at Publicly Buzzed. We do a lot of different streams. We cover a lot of different cases, and I appreciate everyone for coming in here. Hell yeah. Let's keep rolling here. Law and argument. Argument 1. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above-styled numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. There's one really interesting part here. And remember, this is James Owens and Sarah Boone, of course. Undersigned counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at the trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. Remember that part. This is James Owens talking right now. And here's what he follows that up with. It was apparent the undersigned trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle the trial in this matter, or in fact, to handle any other phase of the trial without counsel. So he's arguing essentially right now something that didn't even actually happen, right? Like he ended up being the counsel for Sarah Boone, and in his own words, has a thriving private practice. So he's already talking pretty highly of himself here. Thinks highly of himself here. Both the Sixth Amendment and as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. And they give out the cases there. There appear to be two exceptions to this precedence. One, if the defendant physically harms or threatens to harm his or her counsel. Two, if the trial court certifies that the defendant will not be incarcerated if found guilty. A judge trial should in the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant. The court must follow a process which protects the individual's right to due process as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel, and if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in the court-appointed trial counsel. So yeah, as we're getting into argument number 2 here, I've got some notes here as well. I heard, and one of the professionals I watched earlier go through this was lawyer, and he was making a point saying basically Owens is saying it's unfair that she was put in the position she was because of all the different appointed attorneys that she ended up getting. But in the end, he stepped up and she ended up being her amazing, knight in shining armor, if you will, in this place. Again, saying that he had a thriving practice. And remember, Sarah Boone was asked over and over every day in trial. You guys remember this. Are you happy with your legal counsel? And every single time she said yes. Judge Kranek was covering his ass on this. He's covering the bases for a possible appellate issue. Had Owens and his team not picked this up, this argument would work a lot better. But from Owens himself, she, and this is from Owens, James Owens himself saying this, she had the best possible team at the time of the trial. Kranek made a record of this, and I think it's pretty clear. I don't know. Let me know what you think about that. Argument 2. The court erred in failing to grant the defendant's motions for the continuance made by undersigned trial counsel. Now, this one's pretty interesting because if you remember how we were leading up to the trial, James Owens, once he did take over and he became her actual attorney, he only had like 45 days to basically prepare for the trial, and he was asking for more time. And something this big, you could see that. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. In this instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th, 2024. This gave counsel 45 days. He's talking about himself here, James Owens, to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Counsel did his best to prepare. Owens did his best to prepare for the trial by traveling to Orlando from Milton on multiple occasions, both for meetings with Miss Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unseen issues arising during trial, and he's going to get into it here. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for this trial. That's his own doing here, that you knew what you were getting into. Was simply logistically unable to be as prepared for trial as he would like to have been, and as Miss Boone was entitled to under the controlling cases cited Spura, I'm probably butchering that one. The court's failure to grant counsel's motions for continuance should result in a new trial. Yeah, I don't know. That'll be interesting to see how, because we're going to see Judge Cranick go through all of this and talk about this, and we're going to see this emotions here, I'd imagine. I hope so. Maybe he'll just answer it back. Be cool if he actually makes him come up there and he's like, listen. But it will be interesting to see how that goes. So Judge Cranick at the late stage, even though all the BS Sarah has put the court through, we all know how difficult that she's been leading up to this, and probably why there wasn't a continuance by Judge Cranick was that very issue. He had had enough. We had all seen that. Question, can Owens prove that Judge Cranick showed, prejudice in this situation? That would be what he didn't actually mention in this motion, but what he actually needs to prove, right? He needs to prove that Judge Cranick has it out for Sarah Boone, which is why he wouldn't give her the continuance. Let's go down through here. Number 3. Again, everyone hanging out. I appreciate it. Hanging out again for another Sarah Boone live stream right here. The court erred. Number 3. The court erred when it denied a motion for the new trial due to an emotional outburst in the presence of the jury, going back to the mom. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Counsel, Owens, timely moved for a mistrial requesting a new trial. And we remember that. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts that have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. He thinks he's got something here. The court is unable to determine if these outbursts affected the jury's decision because no inquiry was made. Under the controlling precedents, the defendant is entitled to a new trial, Owens says here. Let's see what I got in my notes here from reading this earlier. This one is interesting because they are using curative instruction, the basis, and I had to Google this one earlier to kind of get a little bit more legal background. There are two types of curative instructions. Instruction or instruction to disregard tells jurors to ignore a piece of evidence that they have already seen or heard, but that the judge has ruled as inadmissible. Limiting instruction. Inadmissible is the end of that one. Limiting instruction is the next one. Tells jurors that to use a piece of evidence for a specific purpose, but they can use it in other ways. So that's what he's arguing there in number 3. And again, I can't wait to see how this plays out for Mr. Owens. And I mean, I saw people saying earlier, of course, Sarah Boone has come back up. She's trying to get a new trial. I can't believe this. This happens basically in every single trial, from my understanding. From hearing lots of legal professionals talk about things like this, this was the next move, honestly. And it's going to get denied. Let's not beat around the bush here. Let's not get silly. The court erred in allowing the opinion of the state's expert not previously disclosed. Now, this one's pretty interesting because this happened live in front of all of us. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat all the time of the offense. This issue was discussed extensively in the expert witness deposition taken, again, if you remember, on October 4th, 2024. The state committed misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert, again, Dr. Warner, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Warner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Given a law here, Section 9.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions or of substantive law. The testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. So, let me see. Owens was allowed to get this doctor's deposition. And again, yeah, we remember that live because he was fucking fired up and mad, if we remember correctly. He was like, wait a minute. No, she's changed her opinion, and I was unaware of this. This goes back to when he was kind of unprepared, and he had 45 days, and there has been a lot of stuff to go through. And as you've seen, even during the trial, he had multiple other lawyers helping him out. He had 2 other lawyers, and they had assistants helping. So to be this unprepared and to still have that much help and so few days, I don't hold that against the defense teams really, or Owens particularly. So I don't know. It is interesting though, because I think that one may be one of the most interesting ones for possibly an appellate issue, if I'm understanding that correctly, because he really wasn't privy to the new opinion of this expert until he literally had to do it in a deposition live right there. But in real time, Judge Cranick did what he had to do, right? He said, yeah, let's do it right now. All right, let's dive on back down through here, folks, as we continue down through this motion. Argument 5, the prosecutor committed misconduct by using a rebuttal argument to make a second closing argument. Now, this one's interesting. It's also short because I think it's probably the least of anything that they have here. And I don't know if they have anything at all. The state committed prosecutorial misconduct, and I know I butchered that. I actually had it up here to learn it beforehand. I still probably butchered it. By essentially making a second closing argument instead of a rebuttal argument, counsel for the state made a second closing argument posed as a rebuttal. Wherefore, premises considered, the defendant seeks the relief sought herein, as well as any other relief to which she may be entitled. The defendant requests a hearing in this matter. So they're requesting a hearing, and they want to do this face-to-face. And it's signed right here, James Owens. And of course, Sarah Boone, was like, listen. But again, this is something that happens, from my understanding, regularly. Like it would be odd if it didn't happen, quite frankly. So, do you think the defense rebuttal was truly a rebuttal to Owens, though? Because you're supposed to have the, initial closing, and then you have the defense's closing. And then they're giving a rebuttal to what the defense said. And they're basically saying, Owens is saying, hey, listen, he gave a full-on second closing argument instead of a rebuttal to what I said. But they're all still talking about similar things. Like, I don't know. You'd have to go out on a limb to kind of say that he was saying anything that wasn't true. I would say there at the very end, Mr. J was hammering it home. But I still don't think I'm sweating like a pig in this room too right now. It's extraordinarily hot here tonight. In early November in West Virginia. Should have cranked the AC on, actually. But yeah, it's an interesting one. I can't wait to see what kind of happens. And as more Sarah Boone stuff breaks, you're going to be getting it right here with Publicly Buzzed, folks. I appreciate everyone for coming in here and being with me tonight as well. This has been cool. And again, there's lots of good stuff, of course, guys, that is going to be coming down the pike. I've got another trial that I'm looking at here. Looking in the Cashapp. Oh, shit. Donna coming through here with $10. Oh, for Gypsy's treats. Hell yeah. Gypsy is going to appreciate the shit out of that. And let me get you on this new wheel that we started just last night. I believe Chris Dewitt, my brother from another mother, is on there starting out. And we're going to get you right underneath there, Donna. Thank you so much for that $10 holler. Hell yes. Let me give you a little love. Yeah, love it. Love to see it. Yeah, a lot of stuff in the world of true crime is what's going down. I didn't get to look in the chat here in a minute. I want to get through that thing. I had my notes ready. Hopefully that I did a pretty good job. Again, I haven't went through a motion or any legal documents in quite some time, and I haven't done it without a professional with me. Maybe, I don't know, in the very beginning I did. Yeah, they would not like to get Bob in here. I know he's incredibly busy with Delphi right now. Bonnie Bailey's hanging out in here. Bonnie Bailey, I'm hoping the package is going to be in your doorstep in Canada very soon. Pammy's hanging out here tonight. Kai's hanging out. Appreciate it. Dixie Parrish in the house. Love it. Forrest. Thanks, everyone. Donna, man, thank you so much for that $10. That's absolutely amazing. Forrest, hell yes. You know what that means, dude? That gets you on the wheel again. Let me get you in here. Welcome to the party. Get some beers in the chat. I already see them flying, baby. That's what I'm talking about. Get some Dr. Peppers in the chat shit for Sarah Boone herself. Let's go. I'm going to give you a Boone's Farm and a Dr. Pepper Force. Welcome to hell in here, bud. Let me get you on this list, man. Hell yeah. There's a lot of members-only content that is exclusive back there in the video section, Forrest. I think that you'll enjoy. And a lot more coming up also. So, yeah. Looking through here real quick. Let's see, Ritz. I wonder how the going to prison party is going at the jail. What a joyous day it will be when she gets on the bus. Yeah, you know that they're going to probably throw an actual pizza party in the break room. All of the crew, everyone that works there, they're for sure already planning it. And could you imagine if we did actually have another freaking Sarah Boone trial? I mean, it wouldn't. What did she think is going to happen? She'd probably change her, she'd probably change everything. And she's like, no, that actually isn't what happened. Let me tell you the real truth. Let me tell you what really went down that night. Absolute psychopath. One thing that I just got in the mail that I need to get on the merch store. Somebody just came through and purchased these. These are on the PubliclyBuzzed.com. A Murder Church sticker. I've got the Meowder Church stickers. But these right here just came through. The classic pink, yellow, white Publicly Buzzed stickers. These things are freaking big too, folks. Nice size on those. I got to get those on the. On the site. That's probably what the next will be for. Probably a couple of these guys right here, actually. Everybody, definitely come back through. Thank you for coming through here. Hopefully you're subbed up. Oh, in South Africa even. Holy shit. Wow, nice. Appreciate you coming through here. Appreciate that. That's what I appreciate about you guys. Thursday night, 9 p.m. Eastern time. Me and Dan should be back on here. Unless I do come on through here tomorrow with something, you never know. But let me show you what the next trial is going to be right here at Publicly Buzzed. Boom. That is coming soon, actually. The Courtney Clinty trial is coming at us. So I'm going to start diving into the facts of that, diving into everything. First articles, first videos released, what's happening now, the motions that are starting up. We got a motions hearing coming up on the 15th. Diving in and going to be presenting that to you guys in Publicly Buzzed fashion. I think you guys are going to enjoy that. It's quite the case. It's a hell of a case. OnlyFans model stabbed her boyfriend to death. Or did she? She threw a knife from across the room. And this knife ended up 3.25 inches inside this man's shoulder, chest area. It actually cut an artery that is incredibly... if you get this thing just nicked, you're probably going to bleed out if you don't get medical attention immediately. And she punctured this violently. So... yeah, we're going to be diving deep headfirst into that one, folks. Pammy, just cuz, $5 holler. Pammy, love you so much. Thank you very much. Let me give you a little love real quick. I'm going to give you the Brooklyn Zoo.
Brooklyn Zoo!
Yeah. Love to see it, Pammy. Thank you so much. As we start, you want some of these stickers? Look at these things. They're a little weird in the green screen. Oh, yeah, you can kind of get a twist on it. Yeah, look at that thing. It's fucking gorgeous is what it is. Pammy, coming through. Get you on this list right quick. Hell yeah. And then we got Nay coming through, showing off 2 months. Good day. Struggled to make it live lately. Still hooked. Nay, thank you so much, and I love it. I love to hear that. And one thing I didn't do, we're going to do them right now. I didn't do freaking bells for Murder Church. Still going to do them right now. Just for you, Nay. Those are for you, Nay. You deserve extra bells. Everybody deserves extra bells, baby. Oh, probably nothing there in the chat. You know what I'm saying? A little something. A little something. We don't talk about it. Yeah. The bell's rolling through. Doing a lot more murder churches here lately also, folks. And again, just trying to, I think that's where the cases should lay, right? Not just classic cases. Of course, Phil Spector is going to continue up. And I'll probably always keep a classic case rolling. But yeah, we got to start diving into some of these newer cases. And Sarah Boone has really kind of lit a fire under me, as I guess a lot of you can probably tell. And yeah, I'm starting to get motivated again to do a lot more of this content. And I think it's going to be a good era for Publicly Buzzed moving forward as we get closer to 2025, folks. As we get closer to the holidays here. I appreciate every single person for being in the Buzz Nation. And I think we can do some damage in the true crime field is what I think. And I think we're going to. I think it's going to be cool. It's going to be awesome. And anybody that did not see my new video, please, as I'm getting ready to send y'all out. Tonight was a short one. I knew that wasn't going to take too long, but go over to the channel and check out a new video that I have laid down. Drop this. This is from Feral Friday, and it's a guy that got caught. This is from an old Cops VHS tape called Emergency 911. And it's a guy that has just accidentally burned down his friend's house after working on a car. The cops and the crew roll up with the cameras and the boom mic right as this guy's having a mental breakdown outside of the house, as you can imagine. After we were watching this, my brother Dan and Chris even in the chat, and I believe Chris said he was joking last night, but the question started to arise, is this guy faking this for insurance money? Is he putting on just a little too hard? And I want you guys to be the judge of that. If you could go and check this video out, it's only 4 minutes long. Leave a comment. Let me know what you think on this. Is that guy faking, or do you believe him? Do you believe that is what's happening in that situation? I don't know. I wasn't as confident in saying that he was bullshitting as much as Dan was. So, love it. Oh, shit. That's awesome. Love to see that. Yeah, man. Hell yeah. Yeah, as soon as Bob's out of the Delphi world, we're going to be getting Bob back on here for sure. Okay? I might jump back over there. It looks like he's live right freaking now. I'm literally about to jump on there. Hold on. Oh, my God. He looks amazing. Look at him. Holy shit. I said, you look amazing, bro. I'm live right now watching you.
He starts going through the process. And if you'll remember when Oberg was on there, she was adamant.
He might not. He probably
She's like, I don't even want the jury looking at the pictures. That shirt looks
damn. Yeah.
Because that only is used to refresh my recollection of what is in my mind. Because there's so many other things going on that one photograph is not reflective of what I based my opinion on.
That's fucking cool.
Like it's many other things. So he says, and he kind of goes into that. He's like, it's very important documentation. Like you really need that.
Love it, man.
So you have
always been so fucking supportive. He's
two
cool
experts
man.
here who have very
fucking love it. Yeah, I'm about to send you guys over there. Let's go. Yeah, if you would not mind, go and check out that video I was just promoting though. Let me know what you think about that. I will see you guys Thursday night. Let's fucking go. Love you guys. Actually, hold on. Let me set that up. I said I was going to send you over there, and then I'm not. I'm sending you over there right now. I'm sending you right back to Bob. Boom. Redirect. Boom. Right there it is, folks. Love you guys. Thank you all so much. I will see you Thursday, maybe tomorrow. Keep eyes on everything. Love you.